Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We have one case to be argued this morning, 22-620, Texas Disposal Systems Landfill against the Travis Central Appraisal District from Travis County and the Third Court of Appeals District. The argument is being recorded live, is being broadcast live this morning, and a recording will be available in the archives later. Justice Devine cannot be present this morning, but expects to participate in the decision of the case. Ready for argument in 22-620.
May it please the court, Mr. Jefferson will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, the Texas Constitution requires that taxation be equal and uniform. The legislature created a very comprehensive administrative scheme labeled the Taxpayer Bill of Rights to enable property owners to vindicate that right to equal and uniform at appraisal review boards and ultimately in the district court. Once the appraisal district sets the property's value, the taxpayer and only the taxpayer may protest to the appraisal review board. Here, the taxpayer did protest on
Well,
equal
presumably
and uniform grounds.
the appraisal district is not going to protest its own appraisal.
Exactly.
You said only, and I thought, well, of course not.
Your Honor, but that, your question kind of highlights the problem with their position in this case, because what they want to do is preserve a challenge to market value, a challenge that they themselves created. So they are attempting, through their pleadings, to present market value, which is no longer contested. It's not something that the taxpayer brought here. It was only equal and uniform, and that's the reason I put the emphasis on that.
But don't you have to look at fair market value to reach the ultimate issue?
You don't have to. In fact, fair market value doesn't matter in this context. What the equal and uniform analysis does is look at public records of comparable properties. And in this case, it was statewide, it was regional, and it was Travis County. You look at those public records, whether or not they were accurately or correctly determined, to decide whether TDSL was being singled out with a $22 million appraisal.
So the law gives the taxpayer the right to be taxed at a value that is no greater than fair market value, but it does not give an appraisal district the right to tax at a value that is no less than fair market value.
Yes.
Is that your position?
Yes, it has to be. So the question really is one of, are you singling somebody out?
Well, that's the equal and uniform question.
Yes.
But both the Constitution and the statute repeatedly refers to the goal of taxing at fair market value. And I think what you're saying is, well, yeah, that gives me, the taxpayer, a right to never be taxed that sets a maximum.
That's correct.
But it doesn't set a minimum for the government.
That's correct.
That's your position.
That is my position, and that's correct, and I think it has to be that way.
Isn't that a merits determination, though? It seems as though this plea to the jurisdiction is really more operating as a kind of a motion in limine, saying evidence of market value of the subject properties not relevant to an unequal taxation challenge. But in adjusting comparable properties to determine whether properties are comparable, isn't the market value of those properties and the market value of the subject property important, because that informs whether or not you're comparing two like properties?
So I think it could be part of a merits discussion.
Right.
When we get back down to the trial court, I anticipate if the court agrees with us that it's jurisdictional, the question of whether they can bring that up as a protest to the district court.
But they didn't bring a market value protest. They just filed an appeal. They said, we appeal from the decision. The decision of the Appraisal Review Board doesn't reflect fair market value and also creates an unequal taxation situation with respect to other properties. That's their position. It's a defense against the ARB's decision, not a particular claim.
Well, Your Honor, if we are correct, and I think that we are, if you look at the N. Ray Catherine Tower case, I think this one sets it out pretty accurately. That case says it doesn't matter what the value is, whether it's market value or how the appraisal boards came up with this figure when you're looking at equal and uniform. So there might be high, there might be low. None of that matters. The question is,
if Catherine Tower said that, that's not what's reflected in the definition, which says a property is appraised unequally if the appraised value of the property exceeds the median appraised value of a reasonable number of comparable properties appropriately adjusted. And so there is a fight about whether these properties that are being used in the set are comparable and whether they've been appropriately adjusted. And the only way you can look at that is through generally accepted appraisal concepts, which would include whether or not you're comparing apples to apples fair market value.
well, when we get back down to the district court, they will attempt to produce or insert evidence of market value. We anticipate that. We will have objections based on the relevance to an equal and uniform determination. And that's a fight that is going to be reserved, I think, for the trial court. The question here is, do we say that the district court has jurisdiction over their market value protest in their pleadings? They say that the case is...
Are they protesting or are they challenging the Appraisal Review Board's decision?
They are protesting the amount that the Appraisal Review Board came to, 2.8 versus 22 million. Their contention is the 2.8 is lower than market value, 22 million. What we're saying is we're not contesting market value. We gave up on market value. It doesn't matter what market value is. The question is, are we being assessed the same as other landfills in Texas, in the region, in the county? That's our position.
You said earlier your position is the appraisal district doesn't have a right to sue for judicial review of an ARB decision in order to ensure market value. Do they have a right to sue in order to ensure equal and uniform? So what if it was the opposite? What if you challenged the initial appraisal based on market value? You said this is too high compared to the market value. And the ARB agreed and knocked it down to 2.8 because they think that's the market value. But the actual equal and uniform number was 22 million. Would they have a right to sue, to challenge the ARB and say it's got to be 22 million because that's the fair market value?
If the protester did not challenge on equal and uniform?
That's right, yeah, you only
no.
challenged on market value.
No, because the statute says the chief appraiser is entitled to appeal an order of the Appraisal Review Board determining the taxpayer protest. What is the fundamental taxpayer protest here? And ours was not market value. We put that aside. We're not disputing market value.
So basically your position is the taxpayer gets the lesser of the two if they're different. And that's the right guaranteed to the taxpayer with no rights guaranteed to the appraisal district. It's just whichever's the lesser, the taxpayer gets to pursue that.
Yes, except, I don't say no rights, because the appraisal review, the chief appraisal can appeal whatever the determination was. So let's say here that they can make...
Yeah, but only on the basis on which you sought relief to begin with.
That's right.
Yeah.
Yes.
They
That's
can
right.
say, well, okay, so you get the lesser of the two, but they can challenge whichever one you choose to go with, whether the number that you end up with is the right number under that category.
Yes, and that's what the case on the merits will be. And they've not given up, and we're not saying that they've given up the right to contest the equal and uniform. We go back down to the district court and we fight that out.
So the Constitution seems to assume that equal and uniform and fair market value are going to be consistent with each other. And here we have at least allegedly a situation where they're dramatically different. Is there an indication in the Constitution as to how you break that logjam when equal and uniform is pointing you to one number and market value is pointing you to another number?
So I don't know if there's constitutional text that answers that, but I think there is an answer, and that is in the next year, the next time that they assess properties, not only TDSLs, but other landfills, that they make the right determination. And so if the market value is actually 22 million, a comparable property should be
They gotta
22
hike
million.
everyone at the same
Hike
time.
everyone up, and then
So
make it
if
equal
that's
and
how it works, then
uniform.
equal and uniform is a superior rule. Because we've got to stay equal and uniform now, and then once we raise the others, we can raise this one. That means equal and uniform is, sort of prevails as the rule that must be followed, and then market value kind of trails along behind it.
Yes, and I think not only superior, but it makes our point that they're different. Equal and
Well,
uniform can be different, not
It's only
always.
superior if it's lower. If fair market value is lower, your position is that's superior.
So the way this process works, it's a taxpayer protection constitutional provision. And the legislature implemented that through the tax code. That's why it starts as a taxpayer protest. Most appraisals are never challenged. And there are a lot of excessive appraisals that go, and the counties and cities are collecting these taxes even though they're higher than they should be, just because most taxpayers don't make this kind of challenge.
Well, and it's not available to the taxing district if the property is valued at under $1 million.
That's right.
So
but-
there's limitations on the taxing authority's right to bring this kind of a case.
There is that limitation, but you think about a county like Travis County or Harris County, $1 million, that still leaves many appraisals that exceed that floor.
Let me ask you this,
yes.
in answer to Justice Blacklock's question about how do you break the logjam under the Constitution when you've got a right to equal and uniform and you've got a right to market value, and those may not be the same. Does the tax code answer that question by saying that the appraisal can't exceed either one of those amounts, so that effectively whichever one is lower is the one that you're going to get if you choose to challenge both?
I think that's right. I think that is true, the lower of the two. But I do think this doesn't leave appraisal districts without the remedy that I just mentioned. And
Which
that
is to say that the lower of the two, that whichever one the taxpayer protested really should have been higher than the ARV said.
And not just for that taxpayer, but for all taxpayers that are similarly situated, making the appropriate adjustments.
In the next
That's
tax
right.
year.
That's right, in the next tax year. And this is a year by year. So the whole basis of this administrative process is to simplify things, to make them orderly. And so you don't have to engage in all of this, insane, the market value calculation is crazy, especially for an entity like TDSL. And
The ultimate job of the jury in the trial court would be to determine the appraisal amount under your challenge, right? And I'm trying to understand how a jury could do that, or is it your position that a jury could do that without understanding the market value of the comparables in your unequal challenge? Isn't it necessary for them to understand the market value of the comparables?
Your Honor, even if it were, and let's assume that it is, let's assume that market value is irrelevant. That doesn't mean that TCAD has.
That's a merits question. I
Yes,
understand that.
has the power to take it to the district court. And so that's number one. Number two, what's important here is the TDSL property here, It's a unique feature. The TDSL, it's a landfill. It's not, I don't know if you've been out there. It's property southeast of here. It's got all these rolling lands and exotic animals, and it's a beautiful place, right? That's what you think of. But the property that we're talking about, the taxing district, the taxing entity is the smaller portion of the landfill. And the landfill, it's a small parcel of land with waste buried on it. And it gives TDSL the right to pollute the property. Putting waste in the land destroys the value of the land. I mean, it's very hard to kind of comprehend what are you taxing? And what's
Destroying the value
valuation
of the land.
Of the
but
land.
In exchange for income producing.
Yes,
And
but
so that gets to this unequal and uniform argument, because part of that is going to be sort of comparable properties that are income producing and that kind of thing. And you've got to weigh that against, you're right, the use of the land for the present benefit of income.
But this is very critical, because the land itself has no value. And so what you're talking about, and this is really what the object is of their appeal, they want to get not to the value of the land, but the value of the business, the value of intangible assets. And in Texas, we don't tax under the property code as ad valorem a business transaction or business value.
So you would disagree with the calculation of market value that imported some sort of income-producing nature of the property?
Yes, and that's why when you look at the comparables, and you'll see this in the transcript of the hearing before the ARB, almost all of the other CADs, the Central Appraisal Districts, do not tax the business value. They tax the land. They look at comparable land next to the property or surrounding region. TDSL is very different. Landfills are very different. That's the core of the dispute here.
Well, but 230101 says that in determining the market value of property, the chief appraiser shall consider the cost, income, and market data comparison methods of appraisal and use the most appropriate method. Doesn't that authorize them to make the determination that an income-producing valuation is the appropriate method?
But that's why I think this is different, because income producing is like an apartment complex or an office building. Yes, it's income producing, there's rents, people are renting small parcels of land. In the land use, land disposal context, you're destroying the property. And the income is not the property, it's the license. It's the license you have.
Does that run with the land, all the permits and licenses necessary to operate as a landfill?
I think it does. Here, I think it does. But you cannot, in Texas, there's no right to tax as ad valorem property a business enterprise and the income that you receive from the business itself, the license itself. And I think that's the distinction here. I've run over time, Your Honor. I'm happy to answer.
Any other questions? Thank you, Mr. Jefferson. We'll hear from the respondent.
May it please the court, Mr. Trachtenberg will present argument for the respondent.
May it please the court, Mr. Chief Justice. Section 42.02 is a critically important tool that the legislature gave chief appraisers to help them ensure that the tax burdens are spread fairly and equally among their taxpayers. Texas Disposal's crabbed interpretation of this statute, and I want to bring us back to the statutory text. It's based on misreading of 6 words, would seriously undermine this tool, and it violates this court's command in Willacy that these meaning of these words cannot be determined in isolation, but must be determined within the larger context of the tax protest scheme.
But those 6 words are important because they say that what the appraiser can put before the district court is a determination of the taxpayer protest as provided in Chapter 41.
Yeah.
Not a wholesale new determination of value.
Well, I'd ask you to look to tab 1 of our bench book, Your Honor, and I want to explain why Section 4202A should be read in conjunction with Section 41.01, so we understand these words. Section 41.01 describes 6 categories of orders that the ARB can enter, and one of them is determining a taxpayer. One of them is determining protests initiated by property owners. One of them is act on motions to compel appraisal rules. And all Section 4202 is telling us, it has actually 2 provisions. It's on written approval of a board of directors, the chief appraiser can appeal a taxpayer protest. That's linked up to A1 of 4101, or a taxpayer's motion to change the appraisal rule under 25.25. All it's doing there is merely identifying a category of orders that is subject to appeal by the chief appraiser. It's not a limitation on the grounds that a chief appraiser can raise in such a challenge. There are only 2 limitations in this provision. The first is that it requires written approval of the board of directors of the appraisal district. The second is, subject to a fraud exception, the chief appraiser may not appeal an order relating to the property valued at less than $1 million, and either of these limitations is at issue here. And had the legislature wished to limit the scope of the district court challenge in the manner Texas disposal suggests, could have easily done so by adding the phrase, on the grounds the taxpayer raised before the ARB, into 42.02A1.
But it does say that you're appealing the order.
That's correct.
You're not appealing the number, and the order, a couple different places says that this is an unequal appraisal order. The board has determined that the protest concerned the following actions: unequal appraisal. And then it says the subject property was unequally appraised, and the appraisal record should be adjusted to reflect a value of $2.8 million. So the order says this is about unequal appraisal, and that's why we're putting it down to $2.8 million, and you're appealing the order.
The order does more than just to resolve the protest, Your Honor. Under Section 41.47, it also sets the appraised value for the property on the tax roll, and the appraised value is what's being challenged, and market value and unequal appraisal are both issues that we have for the first time after the ARB acts, the first time to say, wait, this isn't market value, this isn't.
But if the ARB wasn't thinking about market value, didn't make any determination of market value, then in what sense are you appealing its decision about market value when it didn't make one? It made a equal and uniform decision. That's where it got its number, and then that's what you can fight about if you're appealing the order that's been issued on that basis.
Well, I think once they lower the value, then we have the right to, that's the first time we have the opportunity to say, wait a second, we have a duty to the system and to other taxpayers to make sure that the appraised value complies with constitutional requirements. At the end.
Sorry, go ahead.
Well, but what happens when the numbers are different? Let's just posit for, theoretically, the market value is what you say it is, and the equal and uniform determination is correct. So for whatever reason, this property is actually worth $22 million, but comparable properties have been appraised at $2.8 million, and just to stipulate that that's what the world looks like, what's the result?
Well, if at the end of the day, we have a right to appeal and those values are ultimately held up, I think there's case law out there that says that, I don't think this court has ruled on it, but I think there's case law that says they get the benefit of the lower value. So, but the question is.
Do you agree that the Constitution provides the taxpayer 2 important protections against excessive property valuations? One is property can't be assessed at greater than market value. And the second is it can't be singled out and unequally taxed in comparison to comparable properties. And the taxpayer gets the benefit of both of those, so the lower number is the operative number.
I think the appraisal system aspires that the numbers are the same. So that they get to the fair market value and that the values are equally compared to other taxpayers. That's why we have the equal.
So if that's how it works, if they get the lower number, then why don't you just say, okay, fine, our claim is just about unequal appraisal, but we think that market value is relevant to that, and so we'll fight over the relevance of market value to the equal and uniform question, rather than fighting over whether we get to separately have a claim that we call a market value claim? Why does that even matter?
Let me give you three scenarios where it matters. And some arise out of this factual context, and some may be more broad. But say here, for example, TCAD can show that this landfill is such a unique property that there aren't sufficient comparable appraisals to methodologically do a sound E&U analysis. For example, there's only one other landfill in Travis County. And so there may be questions about whether you can look beyond Travis County. Even if you look beyond Travis County and look regionally, the question is to the appraised values of other landfills. Do you have the type of comparable data about what are their income streams from their contractual arrangements? What are their, do the appraisal districts have information about what the expected life is? How much longer will those landfills be in operation to absorb more trash? And so we could make a case below that says there is no methodological proper way to do an E&U comparison here, and so we need our market value claim so we get to a final appraised value of this property.
But it seems like in that circumstance, you would, if you won on that, say that the court agreed with you or the jury agreed with you on that argument, that there's no way to do an equal and uniform analysis here, it seems like you wouldn't even need to get to your market value protest, because the answer would be, well, we go back to whatever it was appraised at.
That's wrong, Your Honor, because what was appraised at, the initial appraisal of $21 million vanishes into the ether once the appraisal review board lowers that value. That is essentially, usually that initial number that is done is under mass appraisal techniques.
So if the district court reviews it de novo and says the appraisal review board's order is wrong, then what does the district court do with that? It can't vacate the appraisal review board's order.
It has to come up with a value. It can't revert back to the initial $21 million. That essentially is gone once the ARB acts. That is not the number that's on the appraised value anymore.
Can it send it back to the ARB in some way and say, now you have to reset it?
There's no statutory mechanism, as far as I know, for how that would work.
So basically, you can't challenge, you agree you can't challenge the ARB decision based strictly on the fact that 2.8 is so far below fair market value. But what you can do is challenge their reliance on the equal and uniform clause as a basis to get the 2.8 by proving a fair market value is 22 million, and therefore there are no comparables that render that unequal and ununiform. Is that basically what you're trying to do here?
That's fair. Let me give you another example just to provide additional scenarios. There may be circumstances where there's a recent sale of a property, right? Recent sale should be the touchstone of appraised value, fair market value. But what if the protesting taxpayer tries to shield that information from the appraisal district and only bringing an E&U protest, and then they prevail, and then you're in the district court? In that scenario, we would want to bring a market value claim to be able to help ensure that sales information is in front of the jury, so we are figuring out the correct appraised value, and that market value
But if they have a separate right to an equal and uniform valuation, then you don't have the ability to
but that market value
throw
might
market value at the jury if they've got an independent right to equal and uniform.
That's true, but the presence of that market value claim and that analysis might influence the jury in terms of which E&U value they select.
But it shouldn't. It ought to be excluded if they've got an independent right to equal and uniform.
I think we're getting way into the merits here. I want to step back into.
Well, exactly. Why shouldn't that be a discussion for the merits about whether you get your market value evidence in to inform the adjustment and all of that on equal and uniform, and then you don't need a separate market value claim?
Well, I think those are asking two different questions. I mean, the fair market value is asking what would a willing buyer pay for this property in an arm's length transaction, and the E&U analysis is definitely takes in market value. And actually, there are two different types of E&U analysis that are different from the one protest that they've raised, where market value is directly relevant in terms of calculating the appraisal ratio. So for on a B1 or B2 E&U analysis, you calculate an appraisal ratio where market value has to be determined to figure out that appraisal ratio. But
it seems like taxpayers would avoid protesting excessively appraised property, appraised greater than the fair market value, if they know that they're going to be faced with the kind of discovery that the taxing authority sent in this case, which may be some of the impetus for all of this satellite litigation.
This case-
50 discovery requests that basically ask for every piece of paper that the landfill has in relation to running its business.
Your Honor, if there were, I want to focus on the evidence in this case, and if there were, well, broader, if there were a chilling effect, we would have seen it by now. This system has been in place for 45 years. Nobody has thought to make the statutory argument that they've made so far. We have had decisions in the Eighth Wonder case, which you were a part of, Your Honor, back in 2012, where it was determined that appraisal districts have the right to bring any claim. They're not limited to the grounds that are raised in the protest. The third court opinion has been on the book for 2 years. We have hundreds of thousands of protests. We have a tiny handful of appeals by chief appraisers. I mean, just the numbers just don't bear out this chilling effect. And again,
This discovery is just incredibly overbroad and irrelevant, and a taxpayer faced with this would offer a jurisdictional plea in defense of it. I'm not saying that's the appropriate defense. It may be more a motion for protection or something like that, but.
that's exactly right, Your Honor. We have all kinds of tools. In every case, we have tools to deal with overbroad discovery claims. And like I said, the differences wouldn't be that great whether we have a market value claim or not, because market value, as you pointed out and as you held in the MPCH case many years ago, that there's an interrelationship between equal and uniform analysis and a market value analysis. And here we would have.
But in that case, again, the discovery was extremely overbroad, and we said no.
And you made your ruling, and people have exercised their rights in Catherine Tower and other cases. If they don't get the right answer, if they don't have it limited in discovery in the trial court, they exercise their remedies in the Court of Appeals. But we're talking about jurisdiction here. And I want to make it clear that because we're talking about jurisdiction here, that if they're right, we have judgments going back potentially 40 years where under these circumstances could be deemed void if this is really a jurisdictional problem, not a merits issue. Right? I mean, because if there have been judgments based on an ENU.
I don't know that that's right. I mean, if it's true that equal and uniform is an independent protection, then if they win on that, then they're fine. And whether or not you've also got a market value argument just doesn't make any difference, except to the extent that it affects the equal and uniform analysis.
Well, I think we can make arguments that there aren't valid. I mean, there are plenty of cases where E&U values or expert witnesses are deemed methodologically unsound, and their evidence doesn't actually survive the court's review. The first example I gave, I think we believe we could show in this case that there can't be a proper E&U analysis with this particular property.
But that would be like a later question of remedy. Like if you do completely undermine the equal and uniform analysis that led to this number, what number are we going to come up with? All right, well, so you've won the case, and then what's the remedy going to be? What number is justifiable? That's different than what your position, I think, is, which is that we get to attack this number on the basis that it is not the market value.
I'm not following. I'm sorry, Your Honor.
Well, what I take the framing here to be is that they're two separate claims, like one of which they're saying can proceed, both of which you're saying can proceed. And the one claim is market value, one claim is equal and uniform.
Right.
And I'm struggling if they have an independent right to an equal and uniform valuation, then how is it that you can attack this $2.8 million number on the basis that it is not the market value of the property? Because it doesn't matter whether it's the market value of the property if it is the equal and uniform valuation of comparable properties.
We're going to be attacking both. We have an equal and uniform argument too. We're going to be attacking both numbers and putting them both in front of the jury, or we're going to be able to say.
But I think what Justice Blacklock is saying is it doesn't matter what your attack is on market value.
But it does if we can show that the $2.8 million here is improper, and you don't even look at the 2.8 in the trial de novo. Let's take a step back. You don't start from the Appraisal Review Board number. I mean, it's on the rolls, but the jury's never even informed of what that number is. Okay, so we're starting from scratch in the trial de novo, and we are ultimately, if we can show that there's no proper comparable analysis for E&U, The district judge has to, under 4224, enter a judgment at the end of our appeal for the appraised value to put on the roll, and we believe we could show through our market value
My point
plan.
is, that's a remedies question if you win on your attempt to undermine the equal and uniform valuation. That it's not a separate claim. There's not an independent basis for the court to undermine what the ARB did because it doesn't reflect market value.
No, it is a
It's just, if you undermine what the ARB did because it's not properly applying equal and uniform analysis, then you get to a later stage of the case where it might matter what the market value is because you got to come up with a number.
I think it's all part of the same case, Your Honor. If the jury, if there's no E&U number before the jury and we have a market value claim before the jury, and we ask the jury what the market value number is, and the trial court says there's no valid E&U methodology for this unique property, then the judge under 4224 is going to enter our number, which is why we want the market value, in this case, practically.
So let me assume that we have a case where there is enough information to get an E&U number, and there's just a dispute about what it is. I understand your concern, and I want to hear their response to it. But assume we have a case where that's not true, and there is some information, and the parties are just fighting about what's the right number of equal and uniform. In that particular case, if all the order is determining is the equal and uniform amount, and I understand your argument that maybe on the merits you'd get some information evidence in about market value to help determine equal and uniform, but why do you need as a separate claim a market value claim in that kind of a case when it wasn't at issue in the ARB and when it really doesn't matter what that number is because the taxpayer gets the lower number?
I think that there are cases where it would play out like that, but there are also other cases, for example, where the judge might say the number that the jury reached on E&U was unsupported by the evidence, and you have to find, you have to enter appraised value here.
And I hear your concern on that. And maybe it's a remedies question, or maybe you need to have this claim for market value and it would somehow be abated until after the determination is made about E&U, because that's really the driver if there is enough evidence of E&U. But I'm not sure I heard whether you agree with that or not. So if there was a hypo earlier about, if we assume that in a case there's conclusive evidence that E&U is $2 million and there's conclusive evidence that market value is $10 million, the taxpayer gets $2 million, right?
That's correct, Your Honor.
Okay.
But I want to really just remember to bring this case back to the statutory text, which is really these 6 words in Section 4202. I don't think they bear the kind of weight that Texas Disposal is asking it to bear, especially when you read it in conjunction with 4101.
Why doesn't the text itself limit the jurisdiction of the trial court by framing it in terms of the taxpayer's protest?
Again, if you look at it in connection with...
To try to narrow the issues for de novo review.
And I understand your question, Your Honor, because I think you look at 4147. I think you have to look at behind tab 2. I think you have to look at the trial de novo provision, which talks about, again, this is a scope of review provision behind bench book tab 2. The district court shall try all issues of fact raised by the pleadings, not by the ARB determination, in the manner applicable to civil suits generally. It's invoking the general jurisdiction of the district court.
Why wouldn't we read that as it's a de novo determination of the taxpayer protest, not a de novo determination of the appraised value of the property?
It's raised by the pleadings. And I refer the court back to the Valero case too. I know I'm running out of time here, where this court very, very plainly just says, is there a property that went through the ARB protest? Was there a decision? Did you file a petition? I mean, 42.21, which describes the content of a petition, doesn't put any subject matter issue-based limitations on the petition either. I think if you look at the context of the entire statutory scheme, including 41.1, including 42.24, including 42.23, you just can't, the reading that they, again, have urged for the first time in 45 years, the first time this has occurred for somebody to raise, to try to limit the chief appraiser in an appeal. I just don't think it bears that weight. I appreciate your time.
Any other questions?
I have just one more, Chief, if I might. Could you just explain to me what would happen? Suppose the court rules against you and concludes, suppose that we accept, this goes beyond what we probably would do. Yeah, it's absolutely $20 million market value, but all the comparables properly mean that under the equal and uniform clause, 2.8 is all that can be. What can be done to correct that in future years? Suppose that we also were to agree all the other comparables are also undervalued for market value.
Your Honor, to be honest, I think there was a discussion from my friend on the other side that it would all be raised up in the next year.
How does that work exactly?
It wouldn't. It would be a race to the bottom. It would be the opposite, because these appraisal districts are operating independently.
So some other appraisal district tries to raise up the value of one of these comparables, will they be able to point to this one and say, well, look, it's only 2.8 in Travis County for this one?
And if they lower it below, then we have another comparable. And then you start having a race to the bottom and a real distortion in the system where you're having this big divorce between true fair market value and what the E and U numbers are. And again, that's the opposite of what is intended in the system. Our districts are graded on how well we appraise at market value and and there are coefficients that are analyzed at how well we're measuring on an equal and uniform basis too. So I think your question raises a great point. I think you see a race to the bottom because of the lack of coordination, not a race, not to bring everybody up the next year.
Any other questions? Thank you, Mr. Trachtenberg.
Thank you.
Mr. Jefferson, you have 5 minutes.
Very quickly, Justice Blacklock, I want to clarify. You asked about running with the land, and I just wanted to clarify that the permit is tied to the land. I mean, that's how landfills operate. But the permit belongs to the permit holder. So this is not like a zoning case where there's a zoning classification that runs with the land. I just want to make that clear. The second thing, again, to Justice Blacklock and Justice Busby, both of you posed a scenario where, in which we agree that the market value is 22 million, okay? So let's just assume that that's true. But we also know that or agree, let's say the record reflects or establishes conclusively that there's an unequal appraisal, that the equal and uniform has been violated. The answer counsel gave to what happens in that scenario, I think, describes our case. Because counsel says, in that instance, the taxpayer gets the benefit of the lower value.
Right, but I think what he's saying is that they don't agree on point 2. They agree on point 1, market value's 22 million. They don't agree that is unequal and ununiform, because all those that are at 2.8 that you rely on are not true comps.
Yes,
And aren't they entitled to rely on evidence of the true fair market value of the TDS property in order to prove that all the 2.8 millions out there are not true comps?
So that does get to the merits, and I think that they can try. And I think we're going to have a defense to.
Well, sure.
Yes.
You're going to argue otherwise, but you're not saying that jurisdictionally they don't have the right to put on that case in this proceeding. Or you are saying they don't? Or?
They have the right to try to put on that case.
Okay.
Or to offer that evidence.
To offer that evidence. Our response is
Which is fair market value evidence.
Yes, our response is going to be that they are basing their fair market value evidence not on the value of the land, but on the value of the business. And
Sure.
So that can be done.
Okay.
All I'm saying.
We understand your argument on that, but what happens in this black hole situation that we're talking about where, say there's a case, just assume that we have a case where there's evidence that the market value is 20 million and that's been conclusively established, but someone is able to conclusively prove that there is no equal and that there really isn't a basis for an equal and uniform valuation because there are no comps. But the Appraisal Review Board thought otherwise and said, well, we think there is, but somebody wins on that issue in the district court, and there's plenty of evidence to support it that there are no comps. What he's saying is, in that situation, if we're not allowed to raise a market value claim, then there won't be any tax at all because the original appraisal number has gone away. So is that right? Do you agree with that? That basically you wouldn't owe any tax at all if they disprove your equal and uniform challenge?
No, but
what would happen?
But I'm sorry to also disagree with the premise, because It's not, landfills are unique, but there's not just one in Texas. There are many throughout Texas. There are ways to assess comparisons here. So we're not talking about, a unique in the sense that there is one single one.
So assume it's a nuclear plant and there is only one. So there's no basis for an equal and uniform challenge. But the ARB thought there was, and so they give a number based on equal and uniform. And it comes to the district court, and that's disproven. It conclusively shown there's no basis for an equal. We can't come up with a number using equal and uniform because there aren't any comps. So does that mean there would be no tax in that year?
No, I don't think so.
Okay, so what happens in that
I
situation?
think the appraisal district is going to have to come up with an amount, an evaluation.
How can they do that?
They'll, if.
Because they say the district court has to come up with that
Yeah,
amount.
if we're protesting on both grounds, which is like the Eighth Wonder case, then that whole case will go to the district court and then up on appeal.
Sure, but assume there's only an equal and uniform protest.
Your Honor, I don't know. I think there's still going to be. I can't imagine a scenario where there will be no taxation, and I don't think that there in any way that's our case.
To clarify, so you agree that if they can challenge equal and uniform at 2.8 based on the fact that by relying on evidence that the fair market value here is 22 million and therefore the 2.8s aren't true comps. You agree with that? You don't agree they can win that challenge, but you agree they have the right to raise that challenge, right? So let's say they do win that challenge. Do you agree that in the district court, it then becomes a process of figuring out what's the fair market value so we can figure out what the property should be taxed at?
If they win a challenge that is not uniform, if they win the challenge that negates our unequal appraisal,
right?
Yes, then
the district court's got to figure out the fair market value.
District court's going to have to figure out the value.
And if they say, oh, fair market value is 22 million, but you can say, okay, well, maybe the 2.8 comps aren't real, aren't correct. We tried our best, we lost on that. But these $10 million comps are true comps, and so in the district court, you can fight over the equal and uniform being something less than fair market value still, but not as low as 2.8.
Well, yes, but I'll say this, and the transcript of the ARB review hearing will show this. We have a lot of evidence on.
But it's trial de
uniform.
novo.
Yes,
we
trial de
don't have
novo.
that record in front of us.
You don't, but I'm just saying you can base there's no dispute that there is, that there are other landfills with other valuations from other appraisal districts. That's true. And in the de novo trial, we're going to present that evidence. And the reason that, this hasn't happened, time and time again, is you can look on page 6 of our petition for review. It's a chart that shows where TCAD stipulated to the lower values for years and years and years. And so it's always 1.3, 1.4, 1.4.
But
and
that chart stopped.
Jump to 22. And the rest.
Interesting that you bring that
Yes.
up. That chart stops at like 2009.
The rest of those are in litigation. That's why it stops. The rest of those are currently in litigation. So we ask that the court reverse and sustain our plea.
You did not challenge the market value, it's only the equal and uniform, that's the whole point of this, right?
That's correct.
So is that market value finding of what the market value is for purposes of other challenges, like, that's what your market value now is that right?
For the year 2019, that's correct.
Okay, and so will that play a role in avoiding the race to the bottom that we were talking about, or not?
I don't agree with the characterization that this is a race to the bottom. What it is the taxpayer right to equal and uniform, wherever that lands, whatever the equal and uniform, it's a race to being not singled out as one taxpayer, given a competitive disadvantage to everyone else in the market that's similarly situated.
Assuming that they all are worth, let's just hypothesize you've got 10, they're all worth exactly $2 million. Would the valuation, if it goes your way in this case and the 2.8 is locked down, is that the valuation that some other challenge in a different county or somewhere else in Travis County will say, well, no, it's 2.8, or will the $20 million market value be relevant to that?
I think they'll look at the appraised value, which would be the 2.8.
Okay.
Any other questions? Thank you, Mr. Jefferson. The case is submitted. The marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.